Good morning, good afternoon, and good evening. By way of introduction, I'm David Hammond, the founder and CEO of the UK-based charitable NGO Human Rights at Sea, established in 2014 with a simple vision to end human rights abuse at sea. First, thank you for giving up your valuable time today and for joining us on World Oceans Day for a joint Shearman Sterling and Human Rights at Sea webinar focusing on and expanding upon our proposed Human Rights at Sea arbitration initiative. This is part of an innovative and alternative route to effective remedy for victims of human rights abuse at sea. Today, we are focusing on the global fishing industry, its community, and the supporting supply chains, with an expert panel of international lawyers, business persons, supply chain experts, and a front-end NGO supporting worker protections and worker voice in Southeast Asia. This event is part of a comprehensive week covering this year's World Oceans Day theme of the ocean, life and livelihoods. And we have stood up to be part of it as we feel it is necessary to ensure that victim-led initiatives reflecting established international law and otherwise well-trodden arbitration routes must be better publicly promoted and adapted to achieve increased social justice and proper enforcement. I say must, as we cannot always rely upon state intervention for the protection of an individual's human rights at sea. Consequently, we are seeking to collaborate with states, industry, and civil society to support the existing rule of law while evolving effective routes for victim remediation through our project work. Before I pass the baton over to Alex Markopoulos, our moderator today, and who will shortly introduce our panel, I wanted to briefly outline why we are developing a new arbitral route as a victim-led approach to justice. That is in addition to existing routes to justice through the likes of port, coastal and flag state processes, and of course, commercial in-house incident reporting mechanisms. So to set the scene, why arbitration? Arbitration is a contract-based form of binding dispute resolution, and we are looking at evolving this into the maritime domain and its supply chains by having it included, amongst other places, in the likes of employment contracts for those persons working at sea. This means that a party's right to refer an incident or violation of human rights abuse to arbitration depends on the existence of an agreement, otherwise known as the arbitration agreement. And this is established between the parties to a dispute, and it allows for that dispute to be referred. Most commercial contracts, as you'll be aware, commonly include a provision for how disputes relating to that contract may be resolved. If the parties choose arbitration, the agreement will generally be part of that document, recording the terms and of the commercial transaction, and that can include the supply of services. Parties can also enter into an arbitration agreement after a dispute has arisen, or it is possible for one party to make an open offer of consent to arbitrate, and that offer to be accepted by the other party, and thereby initiating the process. And that is also a form of agreement. So in entering into such an arbitration agreement, the parties agree to refer their dispute to a neutral tribunal to decide their rights and their obligations. We are developing ways for consent to arbitrate human rights disputes to be given, the process by which such tribunals can be constituted, and the procedural rules that will govern the conduct of such proceedings. So to be clear, arbitration is not the same as mediation or conciliation. A mediator or a conciliator can only recommend outcomes, and the parties can choose whether or not to accept those recommendations. In contrast, an arbitration tribunal has the power to make decisions that bind the parties. And one of the main attractions of arbitration and what we're doing within our project is that it is often easier to enforce an award in another country than it is to enforce a court judgment. It's this angle that we are developing in our emerging work. So to wrap up from my opening, I would like to sincerely thank our collaborating team at Shearman Sterling for their very significant support these past 2 years of the project, our panelists who will be coming on shortly, the UN World Oceans Day team, and of course our core funders for enabling this event. And finally, this session is recorded and it will be made available to everybody who is registered, as well as being subsequently available on the Human Rights at Sea platforms, including the dedicated arbitration project website. Alex, over to you.
Thanks very much, David. I'm Alex Markopoulos, counsel in Shearman Sterling's International Arbitration Group, and the lead member of our team partnering with Human Rights at Sea on the Human Rights at Sea Arbitration Initiative. And as David mentioned, I have the honor and pleasure of moderating today's event. We're absolutely thrilled to have with us today a superstar roster of panelists who are able to cover a broad spectrum of issues related to the failure of human rights protection in the fisheries sector and international arbitration as one potential solution to what we've termed a crisis in that sector in particular. Now, these speakers come from different perspectives, some from the business side of the sector, some from law and academia, and others working directly with fishers who have experienced human rights abuses. And that's what the event today is really all about. The hope is that our conversation today will help take this innovative idea that we've been working on, international arbitration as a means to an effective remedy for human rights abuses at sea, and begin to join up that idea with the practical realities on the ground in fisheries, not only for fishers, but also for all industry stakeholders. Because as David introduced, as David mentioned in his introduction, arbitration is about consent and about agreement. And for this system to work, we need buy-in from all the necessary stakeholders. So without further ado, it's my honor to introduce our panelists today. And I will begin by introducing all of them. And then we'll leave it to each of them in order to say a few words about themselves and the perspective that they're coming from in today's discussion. And then we'll do a bit of Q&A in that order. So first of all, we have Ana Maria Soto, who works for the Asara Institute, an independent NGO based in the US and Southeast Asia, which is dedicated to tackling issues of human trafficking and forced labor through empowerment, partnership, and innovation. Ana is Asara's regional empowerment manager based in Bangkok. She's led and worked in research on empowering and disempowering factors in survivor services and post-trafficking assistance, and on repayment of migrant workers' recruitment fees. We also have with us Professor Parosha Chandran. Professor Chandran is the first ever professor of practice in modern slavery law, if I'm not mistaken. She's at the Dixon Poon School of Law at King's College, London. She is a specialist in modern slavery law and human trafficking law, and she's also a human rights barrister at One Pump Court in London. We also have with us Richard Stavis, who has over 35 years in the seafood community. He's worked at Stavis Seafoods, a Boston seafood distributor, as its CEO and later as Chief Sustainability Officer. And he's since transitioned into a consultancy role, having formed Stavis Consulting, through which he advises NGOs and companies on seafood sustainability, including with respect to labor practices. We have as well John Burton, who's been involved in the food industry his whole working life. In 2010, John founded Worldwise Foods, which is a UK-based importer and supplier of sustainable seafood, specializing, among other things, in pole and line tuna. Through this and other efforts, John has been instrumental in helping to develop demand for more eco-friendly seafood in the UK. So he can also speak to us about getting the public behind initiatives like the one we're proposing. And last but not least, we have Elizabeth Markopoulos, who works together with David at Human Rights at Sea. She's been there for the past 7 years. She's the charity's program manager, and as such, she oversees its projects and programs with the aim of delivering on the organization's charitable objectives. Elizabeth is also a lecturer in international law, international human rights law, and refugee law at the University of Westminster and at UCL's Refugee Law Initiative. So that's the superstar lineup of panelists we have with us today. I'd like to turn first to Ana. She is one of the people who I mentioned in my introductory remarks, has the direct connection with the people on the ground, the ones we're really trying to help. So Ana, maybe you can say a few words more about your background, and then we'll ask you some questions.
Sure, thank you, Alex. So yeah, let me share more about like what we have done at ITSARA Institute and what do we think is important to be taken into consideration when setting arbitration efforts. So ITSARA Institute has provided direct assistance to trafficking and forced labor survivors from the fishing industry. And we have conducted research on labor risks in this industry, as well as research on effectiveness and impacts of post-rescue services for trafficking survivors. This direct relationship with survivors and the research we have conducted have shown us that there is a need for greater recognition of survivors' agency, their short and long-term needs, and their desire or not to follow legal processes, and the impact that these processes have in their lives. And when it comes to access to justice, which is what we're discussing today, one of the biggest issues with legal processes is that they take very long time. And with those long procedures, survivors face a variety of challenges, such as being sent to shelters against their will, where there are restrictions of movement. They can work, they can return home either. So since they can work and earn money, this creates a disempowering situation and a desire for the process to end, even if they haven't received the compensation they're entitled to get. And in some cases, processes can take very long and result in very little compensation to survivors. Now, in regards to international arbitration, we believe it can play a role in improving human rights in fisheries, in a sense that it could represent an accessible channel for exploited fishermen to seek and find justice, and it could help recognize the different human rights violations faced by survivors and what they are entitled to receive as compensation. But we also think it's important to acknowledge the different needs from survivors and other services and channels they can use, and not sacrifice those efforts to get a remediation for exploited workers in a reasonable timeframe. This is in large part driven by the interest that exploited fishers themselves have articulated to us over the years of not wanting their lives tied up in a big legal case that takes massive time and energy that often yields little for them without attention to the things that really matter to them, like getting a new and safe job, stabilizing their family and themselves, rehoming, addressing mental trauma, and so on. So I want to note here that responding to all these needs can be complicated and can take time, effort, and expertise. And these services are provided by organizations that are on the ground. They understand the context and the client's needs. So apart from a group of lawyers responding to a case, it's also important to have a strong team or network of organizations that can provide that extra support needed. And apart from that, I will also like to add that the burden or presenting and representing compelling evidence so often falls on survivors in a way that it's detrimental to their recovery. For survivors having to tell over and over again what they have experienced and trying to prove that the abuse happened could be very disempowering, and it could harm their mental well-being and recovery. This is why it's important for arbitration efforts to have an emphasis on a strong investigation and building an evidentiary base that is not over-reliant on representation of survivors. So all these points that I mentioned, such as acknowledgement of survivors' agency and their interest to follow legal procedures, recognition and response of their needs, and having strong investigation methods not over-reliant on survivors themselves, are some of the different aspects we consider are fundamental to take into consideration when setting these efforts of international arbitration for it to result in positive experiences, resolutions, and remediation for survivors.
Thanks so much, Anna, for your remarks, which are not only helpful to the work that we're doing, but also really, really eye-opening. I wish we had all day to go through and unpackage all of them, but I want to focus, first of all, on what I think you referred to as arbitration as a possible accessible channel. And one of the things we want to do is make sure that any system, any arbitration system that's introduced is actually able to be used by the people it's designed to be used by. And I was wondering whether you might be able to say anything about what the main barriers to access are now. I mean, you mentioned disempowerment and people not wanting to go through a very long and perhaps expensive process. But as a practical matter, can fishers even raise complaints when they're subject to human rights abuses? What sorts of issues would need to be taken into account in that regard?
Sure, thank you, Alex. So remedy cannot be access for human rights violations that are never identified. So this is the very first barrier we see. Government inspections and vessels audits, vessel level audits in our region have proven to fail to find labor abuses. So there is a need for self-identification, for example, by workers calling NGOs or some helpline. But we see that even for fishers that have some awareness of their risks, perhaps having received some training on their rights or given pamphlets and so on, they may feel like it's not worth reaching out to help since they are so difficult to reach sometimes, perhaps at sea or perhaps fishing based out on a remote area. So it's so easy to suffer retaliation for calling someone. And then when it comes to barriers to access effective remedy, once victims of human rights violations are identified or self-identified, we can say that there are like there are some language barriers, right? So like there could be like limited number of available interpreters, or the quality of interpretation is poor, which not only impacts the legal process, but also negatively affects survivors' ability to express their needs and concerns, and it limits their understanding of how the process is being handled and so on. So there are also some barriers to access remedy when there aren't services and assistance that respond to the different needs of survivors. In a sense that if those short and long-term needs are not recognized and addressed, survivors could decide not to follow any legal procedure because their bigger concern could be finding a new job or finding financial, physical, and mental stability, for instance. And when there are legal processes that take very long time, so survivors face another set of challenges, as I mentioned before, such as being in shelters, not being able to earn money or return home and find stability. So apart from interpretation services and services to meet survivors' needs, there are other challenges to access effective remedies, such as difficulties with the process of collecting evidence and or prosecuting some small actors in the of the violation, such as brokers, and not the trafficker or the bigger responsible party, which results in survivors not receiving the monetary compensation they are entitled to receive because the broker can't pay the amount.
I can see evidence in particular being an issue, and it's one of the points I wanted to explore with some of our other panelists as well. But what I wanted to ask you, and correct me if I'm wrong on the facts here, but in the reading my team and I have done, it seems like in the fisheries industry, you have a particularly difficult situation at times where fishers can be on a vessel at sea for many months, perhaps even over a year at a time, because the vessel, instead of going back to port to unload and change crews, is met by I think it's called a mother vessel at sea to be restocked. So in terms of evidence collection, I assume there would need to be some sort of interaction with the vessel or some sort of training before the voyage so that potential victims know what to do. Is there anything you can say about that, or any role that you see organizations like yours playing in that sort of process?
Sure. Thank you, Alex. As you noted, for sure there are many challenges when reporting cases and abuses that happen at sea. So maybe I can start with an example from one legal case we supported around 5 years ago, which was identified initially through calls to the ISARA hotline. Some Burmese men on a Thai fishing boat in Kantang province had received ISARA hotline number. when they were at sea, they did not have any connection except when the boats in the fleet came together for transshipment at sea. Then they got the signal of the motor chip. This is when fishers will call us, and over the course of the weeks, they will just continue to briefly call us, share with us all the information they had in hand, even sharing GPS coordinates, voice recordings and photo to help them. And one person was eventually discovered to have been calling us, and we were able to work with the Thai Department of Special Investigations to get a nearby Navy chief to rescue the man right before that man was to be killed as retaliation for calling us. And over the following years, we witnessed this man essentially held captive against their will in the government shelter system, then eventually be sent home empty-handed because while the boat owner was prosecuted, he was not paid to pay any damages, and the government did not pay the own administrative damages and support either. So this shows us that fishermen can actually make calls and be very brave and self-identify themselves. And of course, like there are impediments because of course there is an environment of total impunity, and there are a lot of risks for them. But what I want to share here, and it comes to your question of like what can we do or what kind of information can be shared with them, is that, well, there is little to no information about safe, trusted channels fishers can use to report a violation. And when there is information about the channel, it could still be difficult for them to access those channels. We have just discussed the limited connectivity, restrictions of movement, no channels on fishers' languages, and also fear and uncertainty of what will happen after reporting a violation. So there are different ways in which that can be addressed. And one is by setting safe and credible grievance mechanism channels accessible to them in a widespread way. So there are 4 points that I would like to share here as recommendations. And the first one is sharing information that is available to fishermen through different means. So not only physical information, but also information that they can easily share online through Facebook, for instance, because we have found that many fishermen, whenever they have internet connection, they will use social media platforms like Facebook to communicate with their families. So it is a good way to share information about the different channels they can use in case of facing any violation, and also provide information about their rights, since education is key for victim self-identification and empowerment. Then the second recommendation is, of course, like have credible channels easy to access, such as hotlines of fishermen on fishermen's native language that can be available 24/7. The third one is making sure there is a strong plan that will allow the fisher to see their needs met. So as I mentioned before, it's fundamental not only to think about access to justice and remediation, but what are the immediate and long-term needs of survivors and how to respond to those needs. And then the last one is global brands, retailers, and seafood industry bodies should be strongly encouraged to stand behind, promote, even require having credible and safe grievance mechanism on vessels in their supply chain and national industries.
Thank you very much, Anna. I think you've illustrated as well as anyone could the need to really understand the different disciplines involved here and really get in touch with the reality on the ground before we try to implement what's really just a theoretical idea at this stage. It's also an excellent segue to our next panelist's contributions. Professor Chandran, could you please say a few words, as Anna did, about your background, and then I'm going to pick up where she left off and ask you some questions about evidence as well.
Thank you, Alex and David and Human Rights at Seas and Shearman Sterling for inviting me to be part of this important discussion today. Well, I'm a barrister in London. I've been practicing for 24 years continuously, and my field is really human rights. I moved into the area of modern slavery and human trafficking in about 2003, 2004. So since that time, I've been focusing solidly on that field. But prior to that, I was looking at war crimes and armed conflict, the use of force and human rights violations that happen even through death penalty cases, etc., race discrimination, quite broad ranging. My interest in this field is very long-standing. I actually studied international trade and the law of shipping when I was a student. Always had a great interest in this field. So where it brings me up to date is that now as a practitioner, but also as a professor of practice at King's, I'm teaching an LLM course to my students about various aspects of modern slavery law that includes as well looking at the plight of fishermen and those working in the maritime industry on the seas, and what kind of remedies are needed to prevent the human rights abuses from occurring from a deterrence angle, but also to then protect victims once they're identified and to enable them to have redress, and ultimately to then change the kind of spectrum towards prevention. So, you know, we're looking at this from different angles. Thank you.
Thanks very much. And picking up where Anna left off, she was mentioning some of the difficulties when it comes to collecting and preserving evidence. And I was wondering whether through your work you've seen or been confronted with similar situations, and if there's anything you could say from a legal perspective about how difficulties like that could be addressed.
Yes, thank you. Well, it's interesting because what I've been thinking about has been parallels with asylum law, because it might not first jump to mind, but I certainly myself have been an asylum lawyer right from the beginning. I did an internship with UNHCR in 1997, so that's 24 years ago, and always practiced in the field of immigration law alongside my modern slavery work. And one of the things that I recognized early on was this interesting difference in the standard of proof that should be applied to the cases of those who are highly vulnerable, who are fleeing from countries with either despotic states or because of some gender-based violence from which they're not protected, or whether it's a religious persecution or whatever. It could be they're running away from human traffickers and trying to seek protection in another country. But they don't come armed with documents that are going to corroborate their story. And so the civil standard of proof, which is ordinarily applied to commercial dealings, actually needs to be looked at again with a very critical eye when it comes to actually dealing with violations of human rights and enabling victims of human rights abuses to have a just and fair chance of establishing their case. So in England, we do not apply the civil standard of proof to asylum matters. We apply something much lower. It's called a reasonable degree of likelihood, and it equates with a kind of test of a real risk. And what you're looking at in those cases is the past as to what the account is of the person, and also what the future risk is in asylum cases, because it's always a prospective look, isn't it? But we don't need to do that prospective look when we're looking at the cases of existing human rights violations. What we should be looking at is softening the burden of proof in these cases, including in international arbitration cases, to a standard akin to a reasonable degree of likelihood. Now, how can this be proven, you know, to suitable test? Well, what we're looking at is the account of the individual themselves as to what happened to them, and being quite fair with understanding the plight and the story and the account that they've given, that some of it may be a little bit, you know, twisted or muddled, but some of it may be quite clear from start to finish. And we also then would look at the country in which the person has been facing the human rights abuses, or in terms of human rights on the seas, you know, what is known, what have human rights organizations reported as going on in those places, so that we can then get a fair appraisal as well of the objective situation. And then we piece it together. Now, when it comes to an individual's account, what we know is often, particularly when it comes to highly vulnerable populations of persons, such as mariners on the seas, which is probably one of the most frightening places in the world to be subject to human rights abuse, because there's nowhere to run, there's nowhere to call, there's no one there to save you or to protect you or to report it to on the boat or the ship itself. And you just have to hope that you're going to survive till you get back to shore. Then we would want to be hoping to have medical evidence, for example, that could, you know, assist that person's claim to be considered to this standard of proof that I'm talking about, because they will have been subjected to trauma. What we know about trauma is that it affects the memory. We have different types of trauma, such as complex post-traumatic stress disorder, which is very well known in medical terms, and there's criteria by which that can be assessed. But what I know in the trafficking field, having done the asylum cases of many trafficked persons who have frankly been subjected to one form of another of forced labor, slavery, servitude, or other fundamental human rights abuse, is that they suffer from something called complex post-traumatic stress disorder, complex PTSD, which is even more critical in terms of the impact on the human psychology and on the identity of a person and on their mental processes, and also on their stamina, physically and otherwise, to go forward, and a lot of help is needed. So what I'm saying is that, okay, I'm just going to take a step back. I was delighted when I was asked by David and yourself to participate in this panel event, because I think what you're doing is absolutely critical. Firstly, you're now bringing to a world stage the plight of those who are on these ships and involved in other stages of processing, for example, whose human rights are not being addressed by really any form of accessible judicial system that is open to all. So what you're doing is not only kind of, you're not only presenting this as in a manner of leadership, which is what's needed to bring it to the top of the parapet wall, but by coming at it with a solution, it enables us to look at that solution you're bringing, and also to then look at what else might be needed as well, in the same way that Anna Maria has discussed. So what I'm talking about is that when a person's been harmed, we are looking at a moral and physical violation that has occurred to them. The harm is very, very deep and fundamental. And when it comes to redress, we should be seeking compensation, really first and foremost, and swift methods of compensation. We should also be considering criminal proceedings, for example, against those who have been responsible for this harm, because first and foremost, the criminal law of every state needs to be directed towards and enforceable against those who harm. Yeah. We also need to have mechanisms by which justice can be obtained. So justice can come in many forms. It can come in the form of criminal proceedings, like I've said, or compensation, but what as well about the right to rehabilitation for the future, and proper looking at vulnerable persons and how this can come to an end. So, but I think also what you're doing is, if we can interest states, parliamentarians are responsible, very importantly, for bringing private members' bills if they're not in government, or by being able to suggest amending legislation, we should be seeing states start moving towards a north compass of enabling liability from civil to criminal, but also towards having an enforcement of this such that it will create a deterrence, because there needs to be a deterrent effect from the effective operation of law. So those are just some of my thoughts at the moment.
Thank you very much, and I'll repeat what I said about Anna's helpful contributions. I wish we could spend all day with you going through all of that, and perhaps another event will be needed in the future to go into the details at a deeper level. One thing you said that I wanted to explore a little bit further, I think you were suggesting that perhaps civil remedy isn't enough, or perhaps money damages isn't enough. When we're talking about an effective remedy or access to an effective remedy, what does that mean in the context of human rights abuse violations?
Well, that's a very interesting point. And so if we look at the history of lots of human rights judgments from international jurisdictions, whether it's the European Court of Human Rights or the Inter-American Court, or the ECOWAS Court in the Western states of Africa, we see a trend of making what's called a declaration of a human rights violation. And that's sometimes to be considered as being just satisfaction enough, that there's been a calling out, a declaration of the violation. But those cases involve violations against states. When it comes to an individual, we do need to have a very sincere and very clear opportunity for the individual to receive reparation for the harm done. So that is compensation, and and compensation can take many forms. It's the compensation for the physical and the mental injury. It should be compensation for the loss of wages, and to have compensation for the trauma and the harm done on top of that. But we do want to have punitive damages as well ordered against companies in particular, and boats, and aggravated damages, such as if one case of violation is found and then it happens again to somebody else at a later date. I mean, you might find, that there won't just be one person to whom it's happened at one time. There'll be a group of persons to whom it's happened. But then after that has been dealt with, and when I say dealt with, I mean in the way of commensurate justice, then should it happen again, then we need to have very grave sanctions. And actually, I think even from a first starting point, that if we're going to be looking at this from the way that you're suggesting, which is from an international arbitration point, and then being able to look at it from a wider perspective as well, such as criminal laws, we do need states to introduce corporate criminal liability against organizations and businesses that are directly involved in the human rights abuses that go on. Because why the human rights abuse is usually conducted, it's in order to force somebody into doing something because it's ultimately going to cost them less money, frankly. You threaten somebody. That in the business context, that's usually what happens. You know, when we go back historically and we see the original beginnings of the abolishment of the transatlantic slave trade, one of the first prohibitions was to issue a fine against the merchant navy, the ships, and the Royal Navy would be sailing towards those ships with the slaves on board, and the ship owners would be throwing the slaves overboard. So they were at risk of peril because and of dying in the ocean, so they wouldn't be found on the ship. But we've never really seen the full circle coming towards empowering victims in the way that Anna's talking about. And so for example, we should have closure orders. Companies should be subject to closure orders where there has been liability established, so that there is the gravest and the greatest deterrent, which is hitting companies in the pocket hard, so that this doesn't happen again to other people are not made victims.
Thank you very much. I absolutely agree. I would add, just for completeness here, that the project that we're working on with Human Rights at Sea, it isn't a criminal process. It isn't a system of criminal law, but we're well aware of the need to keep that as a viable avenue for victims to pursue. And so we're carefully trying to craft the system so that it doesn't interfere with a victim's ability to raise a criminal complaint and for that complaint to be prosecuted. I'm also hearing that there are probably other changes that are needed, perhaps on a legislative level, state level, but you also mentioned businesses. And this is a point where I'd like to bring the business representatives into the conversation. I'd like to hear from Richard Burton and John Stavis a bit on their experiences. Perhaps I could ask you gentlemen to say a few words about yourselves first, and then I'll have some questions for you. Let's start with Richard, if we can.
Sure, and just to clarify, you just swapped us. I'm Richard Stavis.
Sorry about that. Not enough coffee today, obviously. Yeah.
No problem. You've done admirably well to this point. I appreciate the introduction you gave me before. Yeah, my name is Richard Stavis, and again, I've been in the seafood business, and I say full time since the age since I graduated university, but actually, my father started taking me into the business at the age of 6 to stamp address tags on Saturday mornings to keep my mother sane. So really a long time exposure to the industry, and boy, has it changed in that time frame. I was CEO of Stavis Seafoods for over 20 years, and during that time period, the company grew to get to a peak of about $250 million in sales annually. And we were doing about 35 to 40 million pounds. And I'm sorry, I'm using, I'm saying imperial, but really even you don't use them in the UK anymore. But 35 to 40 million pounds a year. And we were importing it at its peak from about 51 different countries. And frankly, at that point, and that was probably 12 to 15 years ago, I really had an epiphany, which was that we didn't really know very well the supply chain from the ocean to our door. I mean, we had product specifications so that we knew that the processors that we were buying from were sending us safe and wholesome food. But the question of who was pulling in the net, the question of how they got onto the vessel and what oversight was going on, was something that really didn't enter into our minds. And I think that that's something which became increasingly important as from the 80s on, as vessels got larger and as they spent more time at sea, probably abuses were going on for many centuries. But there was an increased incentive and increased capability, and the farther people went out to sea, the less likely anybody was to be able to see them, and also the more ambiguity about oversight, about who has responsibility, who's jurisdiction. From our perspective as a seafood company, certainly in the 90s, our legal exposure was simply to ensure that what we got was compliant with U.S. food safety laws, and to make sure that it didn't violate the laws of the country from which we were sourcing it, which is a nebulous standard. Because we don't necessarily have the basis to evaluate that, and certainly no transparent way to be able to identify it. And frankly, until very recently, there haven't been good tools, there haven't been good risk assessment tools, there hasn't been a good way of forcing transparency. No satellites until recently, nothing really that we could really use. So, I mean, what did we do? For a while, what we did was we focused on audits. We focused on certificates of vessel assurance, and on different tools that were trust-based to ensure that the workers who were involved in bringing that product to from the ocean to people's doorsteps were treated with respect and were safe and had life options available to them. But as I was getting progressively less comfortable, what I did was I narrowed our supply chain. I narrowed the number of countries that we were sourcing from, the number of products we were sourcing from, and ultimately, with my family, we sought out a fishing company to purchase our company, so to create vertical integration, so that there would be transparency to the labor side of things, which created certain it allowed, once that happened and I transitioned from CEO to the Chief Sustainability Officer, I at that point was able to map the labor on the vessels that our parent company owned, was able to ensure that people had medical care both on land and at sea, that they could embark and disembark at will, that they had their own the national documentation, had worker voice, all these things. Again, I still had issues with validation, but certainly was a lot farther down the path towards having some comfort. And one of the things that I've really been focused on are what are ways that businesses, and now I'm looking at the business that I was in for 30 plus years, which is what I would call a first receiver, not a fishing company, but a company that's importing product, or a company that's maybe buying domestically from the fishers. How can a first receiver have comfort and confidence, and how can they be part of a process of validation to ensure that that product was harvested in a way that gave all of the workers those protections that were required. And there were different ways that I worked to try to make that happen. I was part of, I until recently, I was primarily located in the United States. I'm now transitioning and spending more time in Sweden, and that's where I'll ultimately be. But when I was in the United States, I was on the board and ultimately on the executive committee of the National Fisheries Institute. And while in there, I was working to make sure that we negotiated even with governments to make sure that they had oversight of the vessels that they had within their national waters. Far from perfect, and I'm not saying I'm proud of all of our efforts, but putting things on the map that were not on the map before. Also, I'm on the advisory committee of SALT, the Seafood Alliance for Legality and Traceability, and I've helped. I've given input regarding RISE, the roadmap for improving seafood and ethics, which is that a website which gives a lot of resources to companies that are getting on the path to understand what they need to do in order to have proper due diligence when it comes to human rights for people who are working within the supply chain. Also, I am the first industry chairperson for a supplier roundtable, which is an aggregation of fishery improvement projects, and I am the industry chair for the Squid Supplier Roundtable, and as such, we've piloted. I put out a white paper internally and got our group to start an IUU sourcing prevention task force, and we're bringing all the tools that we can to bear to create enough transparency so that we can know with assurances that our processors who we're sourcing from are not utilizing seafood that was harvested from IUU fisheries, illegal and unregulated and unrecorded fishing. Now, I apologize, some of this may be too much of an aside. As we're talking about the arbitration, this is something which is, I think it's a much needed tool. Because as I said, a lot of what I'm looking at right now is that we need to have tools in our toolbox. It is certainly not going to solve all problems, but one thing that it does is that it helps us all basically it helps us get past that issue of sovereign rights and of who has jurisdiction when something occurs. Because if we have all countries agree that they are part of this overall arbitration system, then that means no matter what water something happens in, and no matter what flag the vessel is, no matter that if somebody has been harmed, or if somebody's rights have been have been violated, that they will have standing through this arbitration system. And that I think it is a great and important step towards ultimately bringing more tools into sort of a universal and a global context, which is what we need in order to be able to move forward.
That is something I want to explore in a bit more detail with you in a few minutes. The main takeaway that I'm getting from your background, Rich, and your history in the industry is business and profit making in an industry like this really isn't antithetical to sustainability and protection or respect for human rights. So at least at that fundamental level, it's good to see that these things can work together. John, maybe we can hear a few words from you as well. And I'd like to get into exploring some of these issues in more depth.
Yes, thanks, Alex, and thanks to Human Rights at Sea and Shearman Sterling for inviting me to be part of this panel today. So I've been around in the world of tuna fisheries, one-by-one tuna fisheries, for more than 35 years. Worldwise Foods, we're a family-owned SME, of which I founded based upon these small-scale one-by-one developing world fisheries. In the last 10 years, I've seen a major shift in the industry. Responsible sourcing is not only about the environment, but very much about human rights too. We as a business have invested in this area and are able to meet the requirements and expectations of our retail customers. We are a leading supplier of responsibly caught Poland line tuna for retailers' private brands in the UK, in US, South Africa, and beyond. So I'm really motivated to engage in human rights issues. And as part of this, I've built a partnership with Human Rights at Sea during the last year, precisely because of the topic of today's event, that those who face human rights abuses on vessels need support to receive remedy and justice. And as David quite rightly keeps reminding us, David Hammond, this is human rights apply on sea as they do on land. So as chief executive of Worldwide Foods, I've got legal responsibilities regarding modern slavery, but that's not my primary motivation. For me, this is an issue of personal integrity. Those who work on vessels are the lifeblood of the industry. The fact that so many face abuses and don't receive adequate remedy is unacceptable. Although not linked to our company's supply chains, my trust, my foundation, Sustainable Fisheries and Communities Trust, has supported recent work with Human Rights at Sea, investigating the death of an observer from Kiribati, which happened more than a year ago. And his family have been waiting for more than a year to establish the outcome. Why was he? Why did he die? It was an alleged murder. The inquiry goes on, but there's just a lack of access to resource or information or influence, and these shouldn't be barriers to justice, which one day we hope his family will receive. So I'm that's one reason why I'm supportive of the arbitration mechanism principle that we're here to discuss today. And I know firsthand that without support to remove the current barriers, victims have no way of securing remedy. Fortunately, to date, we've not found the kind of critical human rights abuses we're talking about today in our fishery supply chains. But if we did, I would want victims of human rights abuses to have the option of bringing a case by themselves and be supported by independent experts to do so. It's not acceptable that inequality, finance, education, connections is a deciding factor in whether abuse victims can access remedy. A couple of points that I'd just like to add before we move on to your questions, Alex, if I may. in the context of tuna fisheries, where a major industry in the world, there is some work going on, and engagement and capacity building is vital in the context of the biggest tuna fishery in the world, the Western Central Pacific Fisheries Commission. Indonesia, where there have been lots of reported abuses to Indonesian crew on foreign vessels, are developing a management measure which will hopefully be adopted in the RFMO to set the scene. And perhaps arbitration should be part and parcel of that measure. There is a UK registered charity that you may be aware of, Marine Stewardship Council, who have been heavily involved in environmental sustainability for the past 2 decades. They really have great access and coverage to international fisheries, but to date they really haven't got under the skin of human rights issues, and they could be a really great organization to engage with on developing this piece of work that we're all wanting to see done moving forward. Thanks. That's a brief introduction, Alex, and questions, please.
Thank you very much. Well, I wanted to pick up on what I thought was a theme that linked what you and Richard had said, which is really that you see a moral imperative here. You just, among other things, want to do good, which makes me feel great that there are people out there in the business world who do think that way. But the cynic in me, unfortunately, doesn't think that that's the way everyone operates. So moving a bit away from the moral aspect, I was wondering whether you might be able to shed some light on why a business, from a purely business perspective, would be interested in consenting to arbitrate complaints of human rights abuses made against it. It just seems like additional risk. Maybe I should start with Richard. Do you have any views on that?
Well, sure. And again, I think it really is important that we identify different players in the supply chain. You do have the harvesters, which are the fishing companies, and then you have the first receivers who are identified. Well, the processors, then you have the first receivers, then you have wholesale companies, and you have retailers or restaurant chains and the like. So you have many players within the supply chain. That complexity has been part of the challenges that we've had. The people who are most likely to be engaged in this arbitration will be fishing companies. And really that's not who you have in this call, unfortunately. So anything that I say is going to be more speculation upon what the motivations are. But the biggest and most obvious one is going to be if they want to have any customers. Ultimately, I think the goal of every, for anything to work, you need to create sort of a universality to it. The reason why businesses are slow to move on some of these things is because in order for business to do any good, to do anything, it needs to stay solvent. And as such, that means that it needs to be on an equal footing with other businesses. So in other words, if you're a first receiver or a wholesaler and you're dependent upon having certain supply, you're dependent upon having supply which is roughly competitive. I'm not going to say head-to-head competitive, but roughly competitive with other product. If you're the only one who's willing to move on a topic like this, you're probably not going to be able to get very far. If only Stay with Seafoods, my old company, if only that company were to require that fishing companies sign on to this the Geneva Arbitration Accord that you're developing, the fishing companies could very easily say, sorry, no gain. We're going to continue selling to every other customer on this earth. And it was nice having known you. And the company would quickly fold. So really, there's two levers that I can think of that would be very effective in terms of getting the fishing companies to the table. Actually, three. One of them is going to be getting the processing and the importing community of different countries united in terms of having that be a requirement. And that probably would start even farther down the chain. What I saw, for example, in the United States was when retail chains required MSC certification, that's when wholesalers and importers started sourcing that product preferentially. And that's what drove a lot more fisheries to become certified. So, it didn't start with fishing companies saying, I'd like to get product MSC certified to be sustainable. It started with the retailers saying, this is our policy. In order to comply with it, you need to get there. And then because ultimately they tightened their policy so that they would only carry sustainable products. If your product wasn't certified sustainable by some measure, you might as well go home because you didn't have customers in your major markets. So you had a financial penalty by going to secondary or tertiary markets, and ultimately maybe you didn't even have enough customers. Now the second lever is and again, now we're talking about fishing companies, the larger harvesters who have multiple vessels and many employees. Most of them, or I can't speak to that, but many of the ones with which I'm familiar have international financing. And those financing instruments with these multinational banks increasingly have ESG, environmental social governance requirements, and these requirements have a lot of things built into them that really require that you run your business responsibly. I could very easily see putting this arbitration clause into a renewal of a financial instrument, a renewal of your line of credit, that if you as a fishing company don't do this, then you're not going to get your line of credit renewed. And if you don't have your line of credit renewed, you're out of business as well. And then the third thing that I would say, and this sort of just came to me right as we're speaking, is that once, as I said, it's difficult for one company, it's difficult for one player to do something unilaterally. Once you get to the point where a number of players are all moving in that direction, that then makes it easier for the rest of the players to move. So there's that momentum-based activity as well. So once it gets to the point where it doesn't become a threat to a business's survival, I think you can get people to jump on board as well. So those are sort of three things that I can see would bring the fishing companies on board. I think the downstream players have less to risk in terms of arbitration, although as you develop it, we might find that's not the case, and have more to win in terms of customer and consumer acceptance once you identify this. But it's very important that whatever is created is created thoughtfully, and that it doesn't create undue risk, because or unfair risk, because if the process of trying to make things better means that you put a bullseye on yourself, on your company, so that all of a sudden you're disclosing that there's risk in your supply chain, but your competitors are not, that's a similar situation where even those downstream players may find that there's too much business risk for them to be able to start championing this.
That makes sense. That makes sense. I wanted to stick with that same topic and hear from John as well. And perhaps, John, in providing your remarks, you could also give some thought to one of the interesting comments that we received from the audience. The gist of it is, fine, businesses like yours might readily agree to consent to arbitration of human rights at sea issues, but maybe not everyone in the supply chain will. There are other companies, or perhaps even other participants in the supply chain, like ship owners or charters, that might not be willing. What do you say to that, if anything?
I think it's a really good question, Alex, and I think Richard did touch on that in his response earlier. I think it's important that we have a level playing field here. There are some of us, Rich and others, who are really leading the way in this field, and it's a bit of an irony that currently those that are transparent about risks that are perceived are, they're perceived as high risk, and those that don't openly talk about risk are low risk. And any mechanism needs to make proactively identifying issues a positive, responsible action. We have the stick and the invisible carrot. The gap between customers' requirements and expectations means that doing the right thing is still not recognized as part of commercial decisions. Avoiding scandal and retaining current business is not a reward. Those who proactively adopt an arbitration mechanism should not be competing commercially with those that don't adopt these. This is not about rewarding businesses for doing the right thing. It's about not rewarding those businesses that continue to avoid their responsibilities. We all have responsibilities here. It needs to be a more level playing field, and all stakeholders have an important role in this, in the supply chain, from retailers going down to importers, going down to processors, going down to vessel owners. And we've got a long way to go to get that playing field level. And those of us that are leading the way are doing a great job, but we're a small part of this matter and this issue. So lots to do, Alex, is the answer. I just see another thing in the question here, Alex. I don't know whether that's in the public domain, but somebody has asked a question for Rich about MSC certified fisheries. I'd like to take that, if I may, because I did touch on that earlier. It says they are obviously the good guys, but are they? They might, in the context of environment, might be in the context of environmental sustainability, but I'd asked you to look at what they're doing in the field of human rights. They have a role to play. They're very well connected in the supply chains, in international fisheries, and in my opinion, they're not doing enough when it comes to human rights. But I'll let others pick up on that. Rich might have his own thoughts on that, but that's my impression. I hope that answered the question, Alex. Did it? Unless you have any follow-up?
Absolutely. What I'm hearing from both of you is that there needs to be a momentum behind change like this. And it's great that you're leading the charge and driven, among other things, by morality. We've already discussed that. But it sounds like for this to really succeed and spread, there might need to be something else behind it. And you'd both mentioned in different ways responsibility that businesses have. And I think that's a good point on which we can pivot to Elizabeth and figure out whether there are any developments in international law that might impose greater responsibility directly on businesses. How can that work? This idea of business and human rights. Elizabeth, maybe you want to say a few words about yourself first, as everyone else did, and then tackle that issue.
Yeah, thank you, Alex. I'm not going to take much of the time introducing myself. You have already done that. I've been with the charity now for 7 years, and I'm also an early career scholar and academic. I'm directly involved in the arbitration project, working alongside David on the part of Human Rights at Sea and yourselves at Shearman Sterling. And my substantive contribution to the project, and hopefully to our discussion today, comes from an international law and an international human rights law perspective. And although I'm not an international arbitration expert, having researched international human rights law at the academic level, while also working on the concept of human rights at sea in the wider maritime environment, including in the fisheries sector, for 7 years now, I can see the value of arbitration as an alternative dispute resolution mechanism for redress, particularly because the maritime environment is a complex environment in terms of compliance or non-compliance, lack of enforcement, and what often is a long and troubled way to remedy. So shall I address your question now on the soft law standards and normative developments? Yes.
Please, if you could.
So I'd like to begin with very briefly with the definition, so to say, of soft law, because not everyone is familiar, and this term has been used variously by different stakeholders. So soft law in international law has been traditionally been used to refer to standards or norms that they're neither strictly binding in nature nor completely lacking legal significance. So they may have some legal significance. It has also been used to refer to instruments that they are not sources, formal sources of international law, such as, for example, resolutions or policy declarations, codes of conduct. But pertinent to our discussion today is the emergence of voluntary normative standards and frameworks developed in a process of consultation with various stakeholders that might not be the usual traditional players of international law, such as states, but it can also be businesses, transnational corporations, and NGOs. So in this area, as you said, known as business and human rights, the applicable soft law framework is the UN guiding principle on business and human rights, known as the Protect, Respect and Remedy framework. So these principles were drafted by the special representative of the Secretary General on the issue of human rights and transnational corporations in 2011, Professor John Ruggie, and they were endorsed by the Human Rights Council in 2011. They came to fill an important gap in human rights protection, and this is in relation to corporate-related human rights abuses. Given the context, many human rights abuses have happened in the corporate sector, and they also came to fill in a gap in affecting remedy. That said, they do not create new international law obligations for states, nor seek to limit the primary obligations of states in international law to protect and respect and fulfill human rights. However, they do encapsulate some normative standards of conduct. And this is what John Berto referred to as responsibilities of businesses. So the addressees of the UNGPs are states, but also businesses. Businesses, regardless of size, sector, location, ownership, and structure. So the UNGPs rest on a three-pillar framework. The first is the state's existing obligation under international law to respect, protect, and fulfill human rights. And part of the duty to fulfill is making sure that victims of corporate-related human rights abuses have access to effective remedy. And the UNGPs urge states to consider the full range of remedial measures. So those measures can be policies, can be legislations, regulations, and of course, adjudication via judicial forums such as national courts and tribunal. So this is where arbitration seems to be supported by the UNGPs.
Sorry, Elizabeth, could I just ask one question about that?
Yes.
Is the obligation owed by the state or by the business? Is it essentially the state underwriting the business's responsibility, or can the wronged person, the victim, raise a complaint directly against the business?
It depends on the state. In the first pillar, the duty is on the state. It comes through the state to protect the human rights. But the second pillar, which is the businesses should respect human rights, we are talking about the normative standard here. We're not talking about a legal obligation that is directly enforceable. Of course, that bears in mind that if we're talking at the national context and there is national regulation that has already enacted legislation in terms of corporate related abuses, then that's a different question. But when we're talking about the GPs as normative standard, the UNGPs, then the responsibility of businesses is a global standard of expected conduct. And the UNGP says that states need to know and show that they protect human rights. And in doing so, they have to put in place, or they're expected to put in place, human rights due diligence processes, which are my fellow panelists have talked about, but also to enable remediation of any adverse human rights impacts. And these two pillar framework meet together on the third one, which is the need for rights and obligations to be matched to appropriate and effective remedies when breached. So in terms of states, as you asked, states must take appropriate steps to ensure that when businesses related human rights occur within the territory and or jurisdiction, those affected have access to remedy. And those mechanisms, as I said, can be non-judicial. And this is where perhaps specialized ad hoc tribunals, as we're looking and exploring in our project, tasked for hearing business-related human rights abuses that have occurred, let's say, can be one such mechanism of redress. When it comes to businesses, they're also encouraged to participate and establish effective operational level grievance mechanisms for individuals and communities. And the UNGPs interestingly suggest that these mechanisms can also be provided through recourse to a mutually acceptable external expert or body. And this is again why potentially where specialized ad hoc arbitral tribunals tasked for hearing business-related human rights abuses in the fisheries context can be one such mechanism of redress. And I'd like to conclude about why arbitration seems to be a step in the right direction and adding value in the long way to remedy, as I said in the beginning. Arbitration is already a means that has been used in bilateral investment treaties, as you're very well know, on the default alternative dispute resolution mechanism. So it has worked. The UNGPs recognize that judicial remedy might not always be the favored approach or the only approach for all claimants. So in this context, arbitration may offer benefits such as speed of access, reduced cost, or has transnational reach. Recourse to arbitration, most importantly, however, if chosen for redress, would not require the individual victim to exhaust prior judicial remedies or prior domestic remedies, which is the case usually with regional judicial mechanisms or supranational mechanisms such as the European Court of Human Rights and the treaty monitoring bodies. So it saves time. And how this could be, how the UNGPs would support something like the project we are exploring would be, for example, flag states can require arbitration as a default redress mechanism for business-related human rights abuses on board vessels, fishing vessels flying their flags. And businesses on the other side could participate in an arbitration-based system of remediation as part of fulfilling their corporate duty to respect human rights and ensuring access to remedy. So these standards might not create direct enforceable legal obligations, but nonetheless, they do have a certain legal significance, and we can put them, use them as a framework against which we can further explore and test the project. And I'll stop here.
Thank you very much, Elizabeth. As you were speaking, I was looking at some of the questions we have from the audience, and unfortunately we're a bit short on time, but these are really excellent questions, and I want to make sure we can get to some of them. One that I noted, actually, Elizabeth, ties to some of what you were saying, but I'd like to pivot and put it to Anna. So the question goes to the grievance mechanisms, and I'm going to paraphrase here because the question was a bit long, but essentially these grievance mechanisms that companies can use. Anna, is there any consultation between your organization or perhaps others you're aware of on how these grievance mechanisms can be structured so that they're accessible to the victims? Is there essentially some bridge between the business entities and the civil society?
Sure, great, thank you. I think that's a great question, and it's actually what we do at ITARA Institute, and is making sure that there are credible grievance mechanisms and the voices of workers are being heard, and that information is treated in a way that can result in positive changes. So in remediation, but also changes in the system for like to avoid this kind of situations of happening again. So yes, like it's really important to say, like, when you set up credible grievance mechanism, what does it really mean, right? Is it just like having a hotline that is operating, or is it like having different channels where workers can reach? Is more about connecting that information with actual remedy and change. I think that's the main point of talking about workers' voice. It's not just like hearing their voices, but doing something with that information. And then once you get the information and you get changes, it's ultimately workers that are validating that those changes are actually resulting in something positive.
And just a quick follow-up on that from Elizabeth, I was wondering whether in the evolution of soft law we're seeing, and just a different view of how business and human rights is to be handled, whether there are any specific guidelines for what mechanisms like this should look like and what they should include.
The UN guiding principles, as I said, is cross-sectoral, so they do not differentiate in the sector. However, there has been follow-up work on each sector separately. It hasn't been done anything in related to fisheries, as far as I'm aware, and I might be wrong, but I'm not aware of any study in the fisheries. There has been a lot done in the textiles industry and a little bit more in the shipping, but in general, since we saw this year and the recently published human rights due diligence tool of the UN Global Compact, IMO, ILO, and the Human Rights Council on shipping industry, by addressing cargo owners and charterers about the crew crisis, is that the point is, this is a human rights due diligence tool. It's not actually referred to remedy or grievances at this stage, but there is a constant need for developing this access to remedy part of the UN guiding principles. It's the most difficult, I guess, the most challenging, and that's why it might have left behind. But there is currently no study or nothing that we can, let's say, emulate and work on, to my knowledge.
So it sounds like we're still at the ground level in that area as well. Switching gears just a bit, I saw a question that actually I had myself as Parosha was speaking. This goes to the standard of proof that you were referring to. The question is, if applying reasonable degree of likelihood standard in arbitration proceedings, would decision makers require training on credibility assessments? And would there be a need to engage competent authorities and, for example, the UNHCR?
A great question. Definitely training would be required in assessing credibility. For example, in the UK, the Home Office is the primary decision maker on asylum cases, just using the analogy. And there's a huge amount of guidance given to the Home Office caseworkers on how to look at this reasonable degree of likelihood, what evidence is relevant, if something is counted to be wrong, that it doesn't topple the whole claim, that corroboration is not a requirement when it comes to the reasonable degree of likelihood, things like that. And so there would need to be, and it can be universal, it can be harmonized training that we could produce, for example, to assist on the application of the standard. I don't think you need UNHCR to be involved, because that is the UN's agency that looks after the interests of refugees. Competent authorities in countries certainly may be relevant, but I think in arbitration, you're not usually using a competent authority, you're using the formula between the company and the individual, with the lawyers, the arbitrators in the middle. So you would need very careful training of the arbitrators themselves as well. And these are very important points. So it is an entirely different way of assessing a case. The standard, the tests, the rules. The best thing about it, and I'm glad that it's being taken seriously because it was a novel consideration that I had, is that there's a lot of case law on this, you know, internationally, on how it should be applied from the asylum context. And so that can assist producing training and guidance for the assessment of such claims to that standard.
I'm going to use my privilege as moderator to ask a follow-up question of my own. I was fascinated when you were talking about the idea that we could take, for example, studies on a particular jurisdiction's human rights record. But I found that to be challenging when we're talking about the high seas, for example, where you may have a number of different jurisdictions implicated in relation to a given event. You know, you have a vessel flying a particular flag, crew members who are nationals of a certain country, the vessel is owned by a company in another country, and so on and so on.
Yeah, I mean,
how do we deal with that?
I mean, it's great to bring it up, because that list is exactly why there's been no proper focus on this thus far. So I think we need to take each strand of that and isolate each one and work out what the framework is, what the matrix is, who's responsible, and to create a level playing field for the equal application of human rights protection, laws and policies, enforcement, and critically, remedies for the individual. So these, it's not like I can't give an immediate answer, no matter how much I would like to, although I think I've learned in nearly quarter of 100 years of practice that usually when you try and jump to a quick answer, it's usually the worst answer as a lawyer. It's better to take time to think about it. So I do think that it's excellent to point out what the problems are, because then as doctors, as lawyers, we can diagnose what the prescription is for each part, right, in order to create a holistically healed whole.
Absolutely. I'm mindful of time. I see we only have a few minutes left, but I had another question for John and Richard. I'll let you decide who wants to deal with it, or maybe both if time permits. But the question is about certification schemes. If there are certified enterprises who are willing to be certified, I think the suggestion from the questioner is those aren't really the companies we're worried about getting on board in a system like this. They aren't the ones who are going to be where the human rights abuses are taking place. And the question goes on, I'm paraphrasing in the interest of time, if entities would agree to arbitration, there probably is not a high risk for them to lose in an arbitration process. So I think the punchline is those who are willing to consent are probably not the problem areas. They're probably not the ones where abuses are going to be taking place. How do we get the other, in quotes, bad guys to be a part of this system and for it to regulate what goes on there?
So we have a minute each, Rich.
First or second?
You go first.
Okay. I mean, so first of all, what that suggests is that people would know whether they were doing things that were violative or not. And I'm not sure that everybody is going to be 100% compliant without knowing it. I think that the trick is you want to get everybody to sign on to the arbitration. When you do, then you can start to do a gap analysis, and the people who haven't signed are going to become that much more obvious. So yeah, don't think of the people who are the good actors, as you think of it, as not being a problem. Get them all to sign on. Then once you do, then you know the few who haven't signed on, they're going to be closed out of major markets. They're going to be marginalized, and now you can put more focus on them because they will have been made visible because they're not going to be part of the big group that exists who already signed on to the scheme.
Yeah, I agree with Rich there, and ultimately, the market should and must decide on this. You know, consumers are reliant upon retailers to put sustainably sourced product on their shelves, and we have certification schemes there. If you buy a certified product, you would expect that not to be tainted with human rights abuses, wouldn't you? Question. And that's something that needs to be developed. But as these processes and certification schemes develop and retailers buy into them to a greater extent, the space for human rights tainted products will be smaller. But we've all got a responsibility here for Elizabeth talked about the UN guiding principles, due diligence, risk assessment. You know, we look at our own supply chains, we look at the high risk areas, and we focus on them. And over time, working collaboratively with the supply base, with processors, and with retailers, and with this process that you guys are developing, you know, we will make some good progress, and we will certainly make life easier for those fishermen at sea who really need the support of you and all in the supply chain.
Thanks very much, John. That's the perfect note on which to wrap up this really, really excellent event. Such a pleasure to speak with all of you today. Not only was this informative, but I think it actually pushed our initiative forward by miles. Very grateful to all of you for that, and would really like to work with you in taking these steps further. As I said, I could spend all day speaking to you about these issues, and I wish we had more time to do that. I just wanted to remind our audience, as David had put up in the comments, that the Human Rights at Sea Arbitration Initiative does have its own standalone website. You can find the link in the comments, and we will put up a recording of this event on the website in due course. In the meantime, please stay tuned. There are a lot of other excellent questions coming out of this event, and we'd like to do something to answer them. So we're going to be working on that as well. Thanks again to all the panelists and the attendees for giving us your time today. And we're all looking forward to really making this work in the next steps of the initiative. So thanks again very much.